The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable of the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We have three cases on for argument this morning. First up, 24-1467 Central Appalachian Coal Company versus DOWCP. Mr. Grigorachi, I hope I said that right.
Yes, Your Honor.
Whenever you're ready.
Thank you. May it please the court, Mark Grigorachi for the petitioner, Central Appalachian Coal Company. Petitioner is before this court not asking that the court reweigh the medical evidence or try to resolve a battle of the experts. Petitioner is asking that this court evaluate whether the administrative law judge and benefits review board provided sufficient reasoning for their decisions in this federal black lung claim, and whether those decisions are in accordance with the law and supported by substantial evidence. This court should ask whether the benefits review board sufficiently explained their rationale for the decision. When this is done, this court will find that the benefits review board forced Central Appalachian Coal Company and its medical experts to explain away an irreversible residual pulmonary impairment that Mr. Estudillo does not have, and wrongly imposed the burden on the employer to explain why coal dust exposure could not be a contributing factor to Mr. Estudillo's asthma. Although this court's review of the factual findings is deferential, it's not toothless. As this court recently observed in Extra Energy, Inc. v. Lawson in 2025, an ALJ may not credit or discredit an expert medical opinion for no reason or the wrong reason. The court is to ensure that all relevant evidence was considered and that the ALJ sufficiently explained the rationale. So when an analysis of the rationale of the ALJ and BRB Benefits Review Board is done in this matter, you'll find that they did not identify valid reasons for their decisions or for discrediting the employer's medical experts. The BRB erroneously claimed that the employer's experts did not adequately explain why Mr. Estudillo, who has 12 years of coal mine employment, does not have legal pneumoconiosis because they, quote, failed to adequately explain why the irreversible portion of claimant's impairment was not significantly related to or substantially aggravated by coal dust exposure. They also go on to state that the employer's experts failed to explain why, even if asthma can explain claimant's obstructive impairment, why is his asthma and resulting impairment not significantly related to or substantially aggravated by coal mine dust exposure.
Was there any dispute that the claimant in this case suffered, he in fact suffered from asthma? There was no dispute about that, right?
My friends on the other side may dispute it. I believe that the evidence is overwhelming that he has asthma. And in fact, if we were to look at the study cited by one of the experts for my friends on the other side, it would confirm that this gentleman has asthma. He has reversibility.
What is it your position that, let's assume that even if they contest it, that there's some evidence in the record to support that. Do you think that's fatal to the claim?
No, that's not fatal to the claim. It's clear he has asthma. Okay. What is fatal to the claim is that when he receives breathing treatment, bronchodilators, he has total pulmonary disability on pulmonary function test, the objective data. When he receives this breathing test treatment, he gets complete reversibility and does not have total disability after the pulmonary function.
I thought it was only
testing.
only partial relief, not complete irreversibility.
Well, but the ALJ had identified and made the finding that prior to the breathing treatment, it's qualifying, which means it's disabling. After the breathing treatment, it's not qualifying, which means it's not disabling.
Well, it means it's not totally disabling, right?
Correct.
Right, but pneumoconiosis, I thought it didn't have to be totally disabling. It just had to meaningfully contribute to a total disability.
That's correct.
Okay.
That is correct. There needs to be a meaningful or a substantial aggravation or contributing factor, right? That's correct. But what we have here, and this court has identified, that the reversibility and substantial improvement such that this gentleman, no dispute, this gentleman, in this case, Mr. Estudillo, when he has this breathing treatment, he has no total pulmonary disability. This court in Consolidation Cole v. Swiger had found that there being with this reversibility and improvement, right, with there still being a residual disabling impairment, that is the key to identifying coal dust exposure as being a cause or contributing factor. In this case, this gentleman, he has asthma, not acquired through coal dust exposure. When he is given this breathing treatment, he goes from total disability to not total disability.
But I think it's Dr. Green and the ALJ considers this, says that this improvement that you see could be treating the other symptoms, other related issues such as the asthma and not necessarily the coal dust exposure.
We would disagree with that. Our experts had identified that this pattern and this improvement to to being disabled to now being not disabled with this breathing treatment is what you would see and expect in asthma, unrelated to coal mine dust exposure. In addition, because you've brought up Dr. Green, Dr. Green had cited to a study that shows that that would support our position that Mr. Estudillo has asthma and his reversibility is diagnostic of asthma. Excuse me, this is at Joint Appendix page 82. This is a study relied on by Dr. Green. Quote, reversibility of airway obstruction after inhalation of a bronchodilator drug is a hallmark in early asthma and has long been regarded as a criterion to distinguish asthma from COPD. That's what our experts say. Now,
Well, let me stop. I'm sorry
Yes.
to interrupt you, but that's the point. That's what your experts say. And you started off your argument with a statement that this is not necessarily a battle of the experts, but that the evidence appears to be conclusive that this the claimant in this case no longer suffered a disabling condition after being treated. But that's the view of your experts. There's the view of the other experts, and one in particular, Dr. Bashida, who, relying on testing results, said that the impairment in this case, even after the treatment of bronchodilators, was only partially reversible, right? So we have that evidence in the record. So what are we supposed to do in this case when you've got this conflicting evidence? The ALJ weighed the evidence and ruled adversely to your client. Isn't that exactly what's supposed to happen in this case? And why are we in any better position to contradict that finding?
Your Honor, I'm glad that you asked about Dr. Bashida and this reversibility. There was never a finding by the administrative law judge or by the Benefits Review Board that Dr. Bashida failed to explain the irreversible portion of pulmonary impairment. That was a finding. And of course, as this court understands, under the Chenery Doctrine, this court only looks to the reasons cited by the Benefits Review Board for its decision. So here, the Benefits Review Board claimed that the ALJ was correct to discredit Dr. Bashida for purportedly failing to explain this irreversible portion of Mr. Estudillo's impairment. In fact, the Benefits Review Board could not even cite a portion of the ALJ's decision where the ALJ made that finding. This is confirmed if we were to look at Joint Appendix 208. That's the Benefits Review Board decision in which they claim that, as the ALJ quote-unquote noted, Dr. Bashida and Dr. Zaldivar didn't explain this irreversible portion of impairment. But they do not cite to, and there is nothing in the ALJ's decision finding that Dr. Bashida did not explain or discrediting Dr. Zaldivar, Dr. Bashida for purportedly failing to explain the irreversible portion of
Well,
impairment.
is there a difference between failing to explain why a particular expert is wrong and, as the ALJ apparently did in this case, finding the set of experts who testified for the claimant more reliable and believable?
In this case, no, because what we're looking at here, according to the administrative law judge, Dr. Green, Dr. Haubrey, those are the experts on the other side. Well, they are credible, they're more reliable because they rely on symptoms, a work history, and objective data. Dr. Zaldivar and Dr. Bashida relied on symptoms, work history, and objective data. How do we distinguish and discern which one is more or less reliable? It's a standard without any meaning. And more to my point, Dr. Bashida and Dr. Zaldivar, they rely on the same criterion, same factors that the administrative law judge believed made Dr. Haubrey and Dr. Green reliable. That same analysis, that same standard should have been applied to the employer's experts. Because they had given the same analysis, rely on the same objective data. And the objective data here does show, without question, pre-breathing treatment, disability. After the breathing treatment, there's no disability.
I guess,
Yeah.
I mean, maybe this is semantic but it doesn't show, it shows no total disability. You no longer hit the qualifying level of impairment where you count as totally disabled after treatment. But it still shows that there is some residual portion of this impairment that does not respond to the treatment. And I'm just not understanding, I guess just as like a matter of common sense, that sounds like there's a residual condition that sounds more like pneumoconiosis because it can't be reversed. Why does it matter that after the treatment there is not a total disability so long as there is still an irreversible impairment?
Judge Harris, that's an excellent question, and the answer I will provide was given by this court in 2004 in Consolidation Cole v. Swiger. And here's the quote: "The presence of the residual, fully disabling impairment suggested that coal mine dust
Right.
was a
That would
contributing..."
certainly be sufficient, but there is nothing in that case that says if it is not totally disabling after the treatment, it can't be pneumoconiosis. It says what is sufficient. It doesn't say what is necessary. I'm just struggling to figure out why it matters that post-treatment, we're no longer looking at a totally disabling condition.
Well,
That the residual portion of the impairment that cannot be reversed is not totally disabling.
I'm going back to Swiger, and
Okay.
Swiger didn't talk about the phrasing what was sufficient. Swiger identified that the residual disabling impairment is key. But we're looking beyond this. We're talking about reversibility and improvement with bronchodilators is a specific finding that weighs against black lung legal pneumoconiosis. This has been addressed by this court.
Just so I'm clear, your position is that if a respiratory impairment is partially but not completely reversible, that excludes pneumoconiosis? That is inconsistent with legal pneumoconiosis?
Judge Harris, I don't want to rule like that.
It sounds like that's what you're saying.
What I'm saying in this case is this gentleman has asthma, he has reversibility, he has improvement. He has improvement to the point that he's no longer totally disabling. And if we look at what this court had held in Fox, XREL, Fox v. Elk Run Coal Company in 2014, reversibility and improvement with bronchodilators are significant factors weighing against a pneumoconiosis diagnosis because black lung is typically irreversible. This gentleman's condition can improve and reverse to the point that he's no longer disabled, which is how asthma unrelated to coal mine dust exposure should behave.
But if we look at the regulations, his is not dispositive.
I'm not,
It's not dispositive. The fact that he's having the improvement, right?
Well, I don't want to rule that it's dispositive. I'm citing to this court's precedent dating back to 2004 and 2014 that these are relevant criterion. The Benefits Review Board and the administrative law judge tell me that it's not relevant. They say it would only be relevant if you could eliminate it completely. And the standard that they want is that if there is any reversibility, it doesn't matter. But this court has identified in 2014.
I didn't get that out of the ALJ and the board decision that, I mean, they're all about the partial reversibility. I think they do account for that. You're suggesting that, that the agency here applied like a bright line rule that if there is any residual impairment, that necessarily means you have legal pneumoconiosis?
I believe that's the approach that they're taking, because they had instructed, or they're holding the employer to the standard to explain away a residual pulmonary disability that does not.
I think they're just saying that once the claimant comes forward with evidence, they need to rebut it, that you can't really credit an opinion that doesn't actually address what the claimant is saying.
Except, Your Honor, there is no obligation to rebut. This is not a 15-year presumption case.
No, not a presumption, evidence. The claimant comes in with evidence from his expert saying, just because there's partial reversibility doesn't mean you don't have legal pneumoconiosis. And then the ALJ says the company's experts just don't address the way that coal dust and asthma can kind of interact to cause problems.
But though that's an incorrect assessment, because from the administrative law judge and the Benefits Review Board, first of all, the Benefits Review Board created this finding and applied it to Dr. Bashida. It doesn't exist. Secondly, the experts, the employer's experts did explain it. There's nothing that would be quote unquote adequate to the Benefits Review Board because the reversibility, according to them, is immaterial. Our experts explained, relying on Swiger as well, the absence of a fully disabling residual impairment after bronchodilators is what you would expect with asthma. There are other factors, but that is what you would expect with asthma unrelated to, meaning it's not caused by, not significantly contributed to by coal mine dust exposure. When we look at what the administrative law judge felt was reasonable, rational, cogent opinions from the experts on the other side, they rely on symptoms, work history, and objective data. That is the same criterion, same fund of evidence that the employer's experts relied on. However, the employer's experts cannot be credible, cannot be reliable, unless they meet this additional burden and this additional hurdle of explaining away something that didn't exist.
So just so I understand your point, you're making a distinction between residual impairment and disability? Those are two different concepts in your mind?
Yeah, yes, I do think that those are two different concepts.
And what you're suggesting is that because the claimant in this case, after being treated with bronchodilators, gets sufficiently better such that although he might have an impairment, it's not necessarily disabling? Is that your point?
That is, the point is looking at Swiger and looking at this absence of a fully residual disabling impairment, which this court felt was, and identified was quite relevant to attributing the impairment to coal dust exposure. Mr. Estadillo does not have the fully disabling residual impairment.
Does he have an impairment?
My friends on the other side may say that he does.
I thought your own expert said that he does. Didn't Bashida say that there was only partial reversibility, there's still some impairment?
Well, he identified that there was some partial reversibility, yes. Yeah.
All right, thank you very much.
Good. Thank you.
Mr. Blair?
Thank you, Your Honor. May it please the court, the justices, counsel. My name is Cameron Blair with the law firm Wolf, Williams & Austin on behalf of the claimant in this case, Mr. Richard Estadillo. And I think the crux here, where I want to begin with this is employers' argument that its experts are being required to explain away an impairment is not correct. Rather, in this case, the administrative law judge acted within her discretion in finding that Doctors Green and Haber provided a better reasoned explanation for the impairment present, including the residual post-bronchodilator irreversible impairment, and that employers' experts, Doctors Bashida and Saldivar, failed to do so. While the physicians may indeed be relying on the same data set, claimant's position is that the ALJ and BRB were correct in crediting Doctors Haber and Green over Doctors Bashida and Saldivar. And I wanted to turn the court's attention to the nature of the residual impairment. If one looks to the pulmonary function testing from August 4th, 2021, which is the most recent testing, Joint Appendix 96, claimant does concede there is an improvement post-bronchodilator, but even in the post-bronchodilator testing, the forced expiratory volume, the FEV, remains at 65%, which is a significantly abnormal figure, as 80% is generally considered the threshold for an abnormal study. The FVC is 78% post-bronchodilator, another abnormal figure. The ratio is 62%, indicative of residual obstruction. The fact that the impairment post-bronchodilator is non-disabling is not necessarily relevant to the issue of legal pneumoconiosis. In fact, the residual irreversible impairment present on the post-bronchodilator testing actually lends credence to claimant's position that even if there is an asthmatic component to the impairment, the irreversible impairment that remains post-bronchodilator, as explained by Dr. Green in his report, is the result of this individual's, I believe, 11.9 years of credited coal mine dust exposure. And just to reiterate the residual impairment here in the testing from the Department of Labor's evaluation, Dr. Haber from January of 2021, the post-bronchodilator pulmonary function measurements resulted in an FEV1 of 60%, an FVC of 70%, and a ratio of 60%. And again, claimant would note, while these measurements are not necessarily disabling on the numbers, I would point to 718-204, in
You
which...
said that, sorry to interrupt you, but you said twice that it doesn't necessarily need to be disabling, but what do you mean by that?
I mean the fact that we do not have disabling impairment on the post-bronchodilator testing does not preclude a finding of legal pneumoconiosis. In fact, that supports claimant's position that this residual impairment that remains even after bronchodilator treatment is related to coal mine dust exposure. And this is particularly true in this case, as Mr. Estudio is a non-smoker, and the only explanation for the irreversible component of the impairment would be the 12 years of coal mine dust exposure. And another interesting...
Do you contest that, well, I guess there was a dispute as to whether or not the claimant in this case had asthma?
I think, yes, there is a reversible component to the impairment.
Which suggests asthma?
That does suggest asthma. Even in the presence of asthma, that does not preclude a finding of legal pneumoconiosis. In fact, asthma, under the preamble to the regulations, asthma falls under the terms that envelop chronic obstructive pulmonary disease, as outlined in 718.201. And even in Dr. Bashida's report, and I believe Dr. Saldivar's, they concede to the existence, not in this case, they concede to the existence of a condition known as occupational asthma, which generally is considered to be when these asthmatic symptoms manifest during an individual's employment. And if you look at if you turn to the hearing transcript here, the joint appendix, Mr. Estudio, that's Joint Appendix 50, I believe, Mr. Estudio complained of respiratory symptoms, including cough, while he was working. He testified to this at the final hearing in this case. He testified to having pulmonary symptoms during his employment. And while he may not have missed time for work due to this, which is the criteria that Dr. Pashida needs to see occupational pneumoconiosis, this position tends to ignore the reality that individuals need to work, and coal miners tend to work through their issues. And in this case, our position is that Judge Apeta acted well within her discretion in crediting claimants' experts, including Dr. Green. Dr. Green, as noted, reviewed the entirety of the evidence of record. He based his opinions on the diagnostic testing, as well as the work history and social history. Specifically, Dr. Green noted the interplay of asthma and COPD, outlining asthma COPD overlap syndrome, and that's what we have here. We have a multifaceted impairment. There's a component of asthma, yes, which may be occupationally related given Mr. Estudillo's complaints of respiratory issues during his employment. Notwithstanding this, we're still left with this significant impairment on all of the post-bronchodilator testing that could possibly be disabling on its own, even if not meeting the standards. This begs the question of whether this individual will be able to perform his job duties based on even the post-bronchodilator results. And again, here we have absolutely no smoking history. And
Can I ask you a question about a statement that your colleague on the other side relies on to show that the ALJ improperly shifted the burden? He mentions that the ALJ said that both of the employer's doctors failed to consider whether the asthma or obstruction were substantially aggravated by the coal miner's dust exposure, or whether it significantly contributed to his disease. And he suggests that that's shifting the burden. Do you agree with that?
no, that is not shifting the burden. That's simply the court, in its discretion, requiring a well-reasoned explanation as to the etiology of this irreversible obstructive impairment.
I mean, it might be a shift in the burden in the absence of expert evidence suggesting legal pneumoconiosis and a disabling impairment. You've got the claimant's experts coming in and explaining why this miner is disabled as a result of coal mining experience, 11-plus years, as you pointed out. And it seems logical then at that point for the employer to, if they want to prevail, to rebut the claimant's evidence, right?
Well, yes, that is just I would say that doesn't shift any burden that the employer has to disprove anything. That's simply the administrative law judge exercising her discretion in choosing which physicians, experts offering opinions are providing the opinions that are the best reasoned, most consistent with the objective testing, and consistent with the language present in the regulations.
Now, this case is a little bit unusual because you don't have the 15-year presumption, which as a result, requires the claimant to do more, right, in presenting evidence. But, so does that at all change the analysis?
What changes the analysis from a base level, instead of asking the question whether the employer has established that no part of the impairment is due to dust exposure? Claimant admittedly has the burden of establishing all elements of entitlement with less than 15 years. And in this case, we would submit that the administrative law judge and in turn the benefits review board exercised this permitted discretion and satisfied the APA requirements in finding that Drs. Green and Haber provided the best reasoned opinions, particularly Dr. Green's thorough explanation of why, even assuming an asthmatic component to this impairment, the fact that there remains significant irreversible impairment post-bronchodilator leads to a finding that this individual's totally disabling impairment was substantially contributed to by his 11.9 credited years of coal mine dust exposure.
All right, thank you, counsel.
Thank you, Your Honor.
Mr. Casserly?
Good morning, and may it please the court. My name is Dave Casserly. I'm representing the federal respondent here. The director just has a few things to address in this case that I'll go through. First, at the outset, petitioner does not challenge our regulation, which I believe Mr. Blair cited, which is at 20 CFR 718-204, which states that an impairment of any type constitutes legal pneumoconiosis as long as it materially worsens a claimant's total disability. In other words, if it has an impact of some substantial measurable amount on a claimant, that's enough if the claimant is totally disabled otherwise from a pulmonary perspective. Here, that's exactly what happened, and the fact that claimant's other disability may or may not have been asthma has no bearing on that. I also want to address quickly Dr. Bashida's opinion. You'll note that—
Can I stop you for a second? But clearly there has to be, the requirement there has to be total disability, right?
Yes.
And then the question is, at that point, it doesn't really matter how you divide up the causation with respect to disability if the time spent in the mines is a contributing factor to that disability, that's enough.
Correct, Your Honor. That's the analysis. First, you determine total disability. If there is total disability from a pulmonary perspective, then you look at the causes of that. And if coal mine dust exposure was a substantially contributing factor, then yes, the miner is totally disabled from a pulmonary perspective.
I don't think there's any dispute as to total disability in this case, or maybe there is. I guess we'll ask your colleague on the other side.
No, that's correct, Your Honor. There's no dispute that claimant here is totally disabled from a pulmonary perspective. I do want to address Dr. Bashida's opinion. You heard in the opening argument and in the both in the briefing here that Dr. Bashida from the other side did not actually make the findings that the board affirmed, or sorry, did not make the judge did not make the findings as to Dr. Bashida's credibility that the board affirmed. In other words, but that's not the case. The board addressed that in several different ways. First of all, the judge discredited Dr. Bashida's report for being equivocal about whether and the effect of a residual impairment. There's not really any difference between discrediting a report for being equivocal about that fact and for failing to address that fact. The second issue, though, is that after addressing Dr. Bashida's report, the ALJ went into length about Dr. Green's rebuttal of that report and credited Dr. Green's explanation that that report was not credible because it didn't explain that asthma could only be a partial cause of the disability at issue here.
Is that shifting the burden improperly?
Not at all, Your Honor. This is another expert on the other side making that opinion. And so it's the judge weighing evidence and using one doctor's opinion to determine the credibility of another doctor's. That's exactly what they're supposed to do in every case. What would be shifting the burden is if there were no opinions on the other side, right? And the judge discredited all of the experts. You can't award benefits if that's the case. But here, using one side's expert opinion to help the analysis of the other sides is not a burden-shifting issue. So in those two ways, the judge directly addressed whether Dr. Bashida considered the reversibility of the claimant's total disability and found that Dr. Bashida did not sufficiently do so. So backing up a bit, if the court were to agree with the petitioner's argument here, that would requiring ALJs to credit or to not discredit opinions, right? Not not have the discretion to do so if those opinions say this claimant has asthma, period, and do not address whether there's a residual impairment or the effects of that impairment. And we just think that is not consistent with the regulations that say that if there's a residual impairment, if it's a substantially contributing cause to the claimant's disability, then the claimant is totally disabled by pneumoconiosis within the meaning of the statute.
Do you have anything else?
No, Your Honor, if the court has no further questions.
Thank you very
Thank
much.
you.
Rebuttal?
All right, thank you, Your Honors. This is the approach that I'm taking. It was identified 2004, and actually before that in 2003. In Consolidation Cole v. Angelilli, this court, the Fourth Circuit, said that an improvement in pulmonary function testing undermines a diagnosis of pneumoconiosis because the improvement is a, quote, result contrary to the irreversible nature of pneumoconiosis. That's what my experts were that's what the employer's experts were addressing here. It was unacceptable and would never be accepted by the Benefits Review Board. There's a lot of discussion about burden shifting, which I think is a very important issue, and it's fully briefed, but I want to identify one fact here before Your Honors that unmistakably demonstrates that the Benefits Review Board was engaging in improper burden shifting. In addition to misconstruing the employer's medical experts, the Benefits Review Board claimed that the employer's experts have a duty to explain why there's no contribution from coal mine dust exposure. And in order to get this duty to impose on the employer, the Benefits Review Board at Joint Appendix 209 cites to Westmoreland Coal Company v. Stallard, decided in 2017 by this court. That is a 15-year presumption case,
Can
Your
I
Honors.
just, I really am struggling with the burden shifting part here, and just want you to, I bet you can explain this to me. So if there were a 15-year presumption, and then the claimant just sort of didn't put in any evidence, it would still be on the company to kind of rule out that the disability was occupationally related. In this case, the plaintiff or the claimant comes forward with expert opinion saying that he has legal pneumoconiosis. And then the ALJ says the company's doctors didn't rebut that, the company's doctors didn't rebut that, in part because they didn't discuss whether there was a contribution from coal dust. On your view, if it's not a presumption case and the claimant comes forward with evidence, expert evidence that would meet its burden, is the ALJ, the company doesn't have to rebut that evidence? I guess I'm not understanding. Does the company automatically win?
I'm out of time. Would you allow me to?
Absolutely.
Okay. No, in the scenario that you're describing, Judge Harris, there would be the traditional weighing of evidence.
Right. And how is this not that?
This is not that because the administrative law judge imposed an additional duty on the employer's experts to explain why coal dust exposure is not a contributing factor.
Right, because the claimant's doctors explained why it was. And so I guess I'm just not understanding if the claimant comes forward with evidence that coal dust is a contributing factor, and if you can't shift the burden at that point to the employer to rebut that evidence, then does the employer just automatically win?
I'm still out of time.
No, go ahead.
Okay, all right.
You can talk as long as Judge Harris is talking.
Okay. Thank you. These are very important questions, obviously, but the phrasing is causing me serious concern because we're talking about shifting burdens and requiring the employer to explain. In this case, make no mistake, the employer's experts did explain why this gentleman has asthma not related to coal mine dust exposure. The administrative law judge won't accept that unless the employer's experts meet an additional burden. And this is critical. The Benefits Review Board, in their decision, Joint Appendix 209, they say that the employer has this additional, or has the obligation to explain why there's not a contribution. Where do they get this obligation to explain? From a 15-year presumption case that has no applicability to this.
Well, perhaps they miscited the case, but that principle still remains, as Judge Harris has described it, right? Once the claimant comes forward with evidence to prove that coal mining dust was a contributing factor to the claimant's impairment, then why isn't, at that point, why isn't it the employer's burden to come forward with its own evidence, which you did, and then it's ultimately up to the ALJ to decide who's got the better of the battle of the experts?
And I would not be as charitable to the Benefits Review Board and say that they miscited. It was a 2017 case. They're importing the rebuttal burden. If it's true, as Your Honor said, they were wanting to import this other burden to explain from a different case, they did it wrong, and they've identified a 15-year presumption case. That is significant and problematic, and that demonstrates that they're bringing in, the Benefits Review Board, the administrative law judge, are bringing in this duty to explain, an explanation that they will never accept, but they're bringing it in from these 15-year presumption cases, because all of those cases talk about the employer's burden and obligation to explain. Even my friends on the other side, they've identified to claim that there's this duty to explain. They cite 15-year presumption cases. That's not a mistake. That's where this duty is coming from. That is the concern.
All right. Thank you very much.
Thank you all.
We appreciate the arguments of counsel in this matter. We'll come down and greet you and move on to our second case. Please be seated. Our second case is 25-1570, Taylor versus United States. Mr. McCaig.
Good morning. May it please the court, my name is Ryan McCaig, and I speak today on behalf of the plaintiff, Timothy Deshawn Taylor. I believe I have 5 minutes reserved for rebuttal, but I would just like to confirm that at the outset.
You do?
I speak today, perhaps surprisingly, I rise in defense of discretionary immunity. Discretionary immunity is absolutely legitimate. It's important. It runs through our Constitution. It runs through our federal statutes. It serves a very important purpose in providing the flexibility for law enforcement to make the kind of judgments without being second-guessed all the time that will allow them to provide us with the freedom and the security that is our sort of, birthright foundational principle. And we know how far that goes back because it goes back to Alexander Hamilton talking about the executive requiring discretionary immunity in the Federalist Papers. It runs throughout the Constitution. It is codified then by Congress and all this stuff with the FTCA, and that's the big issue here. Now the FBI, as much as good things as I have to say about this, the discretionary immunity exception, and why I believe it is a necessary tool to prevent unnecessary, vexatious, sort of annoying litigation tying up the law enforcement in the courts. as much as I believe in that, the FBI has actually taken the position in their briefs. They've cited, and there's case law that they've cited it from, although perhaps it doesn't go as far as the FBI would have it go. They would say that the discretion is absolute, that they are free to abuse the discretion as much as they want.
Counsel, I don't read the government's briefs that way or the district court ruling that way. I think everybody, for present purposes, everyone seems to agree that the discretionary function exception runs out at the point where there's a constitutional violation. What the district court held was that the complaint didn't sufficiently plead a constitutional violation, and I don't see you responding to that in your brief.
Oh, well, I could respond to it now more
Well.
clearly. It's, well, it's difficult because, for instance, the arrest that was made for the McDonald's robbery for the second time, that's not a constitutional violation in and of itself because the arrest was lawful, okay? It satisfied the federal statutory requirements for it. Now, I think the real problem that you have here, though, and we have cited this in our complaint, is you have this idea of an equal protection violation, for one thing.
Well,
You-
can I just,
Sure.
I agree that your complaint raises the equal protection issue, but I'm concerned that your brief on appeal doesn't argue any constitutional violation. It just argues that if there is a constitutional violation, then there's no, you're not within the discretionary function exception, but your brief doesn't argue the constitutional violation.
It may not have put it in there as like it should have in terms of the focus on that. I think what runs throughout everything we've written, though, is that there were similarly situated people. There were the two people that were the real killers. They were white. And then there were the two people who were innocent, and they were black. And they were treated very, very differently. And we've alleged that the government knew that the two black men who were accused of this publicly by the FBI, that the FBI knew or had to know that by no later than 2009, because an alibi was checked out. They were found out to be 4.5 hours away from the site of the kidnapping at the time that the kidnapping occurred. So it was objectively impossible for them to have done this. And the government itself admits that it knew since 2018. Now, this case presents some extremely unique facts and some extremely horrifying facts. They say hard cases make bad law, which is why I haven't really suggested a specific test in this. I've more said there's certain things, we see this in the Constitution all the time, that they didn't even think that they needed to write down. Things that you would put in the natural law category or something like that. But in this case, what we're essentially saying is that one thing that the government cannot do is it cannot essentially bring charges against somebody that it knows is innocent of a crime just for the purpose of manufacturing evidence against somebody else that they know is objectively innocent of the crime. That's what happened here. The court doesn't have to strike out a 10-part balancing test or anything like that. All the court has to recognize is that wherever the outer lines of immunity lie, this is somewhere far outside of it. This is, frankly, it's outrageous that the FBI, well, not only that they did this, but we still haven't even heard any remorse from them. And if they can do this to an American citizen, they can do it to anybody. All the guarantees of freedom, of liberty, they don't hold. And the immunity.
Mr. McKay, can I interrupt you for a second? So
Yes.
you mentioned the alibi. I think you alleged that in your complaint. You say today that it was an ironclad alibi. It's not clear to me when the FBI might have known about that, if at all. But wasn't there, weren't they relying on a testimony of an informant who indicated that your client had in fact been involved in the murder?
They were relying, supposedly, it's been a little bit hard to get information on what they were relying on, but there was certainly an informant that they did rely on. Now, the person that made the initial alibi finding, we allege that they knew about this. I mean, whether it's
Knew about what?
Knew about that the alibi had been established, because the original task force that took it over, it started off as a state task force. They're the ones who determined the alibi. The FBI then came into it. I would say by constructive knowledge or by just getting the file. Surely they read that. Surely they knew about that. They had to have known about it. Every officer, as we talked about in our complaint, everybody knew it was
But,
being
part of an investigation is, so you may know about a potential defense as an investigator, but you've got an informant who suggests that your client was actually involved. I mean, is the FBI just supposed to fold up their tents and go home?
No, I'm not saying they're supposed to fold up their tents and go home, but that casts it as sort of a negligent investigation. This was something a lot worse than that. This was knowingly using all of the might of the federal government to try to destroy what they knew to be an innocent man.
Counsel, can I mean, the facts alleged in the complaint are very compelling, no doubt. But I'm just trying to get my hands around the kind of unusual posture of this case. So the district court, even putting to one side the discretionary function exception, the district court said even if that didn't apply, it would have dismissed the complaint on 3 other grounds: statute of limitations, which you do contest, but then also the defamation exception and the heck bar. And you didn't object to that, to those 2 grounds in the district court, and you don't address them on appeal. And so I'm trying to figure out, I think we have to take those rulings as a given, that the heck bar applies and the defamation exception applies.
I do. I concede essentially both of those things.
Okay, well then let me ask you, why
Okay.
doesn't that suffice to make this case dismissible?
Well, because for the heck statute, what the state says is that essentially we're trying to invalidate the McDonald's robbery and the conviction. We're not doing that at all. We're
Well,
not.
then that is an argument for why the heck bar doesn't apply. But again, you never made that argument in the district court or on appeal. So let's assume there's a heck bar and you can't raise claims that are related to the McDonald's robbery conviction. And let's also assume that the defamation exception applies, so you can't raise claims that arise from the FBI's disclosure of information.
Right.
If that's out, is there anything left of the case?
I think that there still is, because I think
What's
that
left?
I think that as far as the defamation here, I know that the state would say that everything I'm saying is really, it sounds in defamation, and I'm trying to build a case that's not defamation because that is an exception to the FTCA. This involved conduct that went far beyond defaming someone. This involved essentially calling down a lynch mob on people, and then once you knew it was there, keeping it there and never, to this day, apologizing for summoning it. And the McDonald's robbery, we don't challenge that to the extent of, we don't say that's improper or anything, except the only thing we would say is that you couldn't do what they, because for instance, as I believe I said in my brief, with the McDonald's robbery, if you wanted to make an arrest on somebody that you might not otherwise make an arrest on, in order to squeeze, some information out of them for somebody that you had a good faith or some hunch to believe that it was true, maybe that would be okay. But what you couldn't do is know that the person is innocent of the crime and use that to sort of bootstrap to go after another person to get one of them to talk, knowing that what you're really doing is you're applying pressure in order to make people manufacture false evidence in order to result in a wrongful person being sent to prison for murder, and a murderer, in this case 2 murderers, being allowed to go free. When you step back from this, even I realize it's very complicated with the law. Everywhere you kind of turn, you kind of run into a wall. I realize that's kind of where I come from this, but you step back from this. and you look at the facts that are alleged against the FBI, what the FBI did, and obviously we have to take all of those as being true at this point under a 12b6 ruling. Does an American have a recovery on those facts? Clearly, Americans must have a recovery on those facts. If not, we are all just one federal agent who doesn't like us away from ruining our lives, and there's nothing that we can do about it. Clearly, that's not that was never the intent of Hamilton and the founders. It wasn't the intent of Congress, because the result of it.
Counsel,
I'm sorry.
my concern is that we also have precedent and strong case law regarding prosecutors being able to investigate and make discretionary decisions.
Mm-hmm.
And I just don't, how do you get beyond that?
Well, it's a little bit different with prosecutor immunity than it is with police immunity.
What investigative? Yeah.
Investigative immunity. Yeah. Again, I think that the difference is, and again, these are very, very unusual cases. That's why it was so difficult to find another case quite like this. The Lamone case is the closest that I found, because it's an intentional use of. It's not that somebody made a bad decision. It's
Well,
not
in that case, that there was the issue of exculpatory evidence, and I think it's the First Circuit said, well, that's why there's a constitutional violation. But I think that's what we've been asking is, what's the if you rely on that case, what's your constitutional violation here?
Yeah, it's again the constitutional violation would be the unequal protection. That would be the strongest constitutional violation. I think it also violates the rights of Timothy Taylor to be arrested and be used, to have that kind of pressure put on him. Even if you were to do the McDonald's thing, to put pressure on him and do all of the things that they did to cause emotional turmoil, knowing that he was innocent and the person they were trying to get him to speak about was innocent. That has to be a constitutional violation. If it's not, and if I may just say that.
But I mean, the distinction here is that Lamone had the actions taken by the FBI in that case led to the framing of someone who was actually innocent of the crime that was being prosecuted. In this case, your client pled guilty to the crime that was being prosecuted.
And that's sort of the wrinkle. That's where I say this involves a larger principle than what existed really in Lamone, but it in no way could be proper governmental. Couldn't be a proper governmental function. And I'll just say, just briefly, if I can, all of this immunity, it's to serve a purpose. It serves the purpose I discussed at the beginning, to make law enforcement flexible and not tie them up and harass them. But to affirm this actually goes for a negative policy. It provides a shelter for federal agents who intentionally, wrongfully, knowingly harm innocent people and set out to do so.
All right. Thank you, Mr. McKay.
Thank you.
Ms. Hamlet.
May it please the court, my name is Kim Hamlet, and I represent the United States. This case presents a straightforward application of the Federal Tort Claims Act's discretionary function exception. Mr. Taylor seeks to impose tort liability on the United States based on the government's investigative and prosecutorial decisions. These choices are protected by the discretionary function.
So can I just, I don't even understand your colleague to be challenging that normally the discretionary function exception would apply here, but his position, and the district court seems to have adopted this position, is that if there's a constitutional violation alleged, then that exception doesn't apply. And I understand that your position is consistent with that, right?
Yes, Your Honor, there is a Fourth Circuit case, Medina, that says that this court, the Fourth Circuit, begins with the principle that federal officials do not possess discretion to violate the Constitution, to violate constitutional rights or federal statutes. The sentence there from Medina, it is in dicta. That case did not involve a constitutional violation, but the government's position as to the Constitution is the same that the court would take as to another federal statute, regulation, or policy. If we look at Galbert, the Supreme Court case that sets out that two-part test for us to apply here, at step one, the court looks at whether the conduct involves an element of judgment or choice. And the Fourth Circuit in Bolger said that conduct involves an element of judgment or choice.
I'm sorry.
Yeah.
I
Yes.
apologize for interrupting. Is it the government's position that the discretionary function exception does not apply if the charged conduct amounts to a constitutional violation?
So the government's position is that if the charged conduct amounts to a constitutional violation where that constitutional provision at issue specifically mandated a
All right,
course of
I
action.
did not get that from your brief. This seems like a new refinement of the government's position. Do you understand that your brief says in some cases a constitutional violation sort of, I'm just speaking colloquially, negates the discretionary function exception, but in some cases it won't?
Yes, Your Honor, and apologies if that wasn't clear from the brief. And what I was getting at with the Galbert step one is that there, the court looks at, is there a federal statute, regulation, or policy mandating a course of action? And so what I'm explaining here as to the Constitution is that the court were to treat that as any other body of law. Does this mandate a
So
specific?
only if it's very specific. So for instance, the Equal Protection Clause, the Due Process Clause, a due process violation, because it's sort of inherently not going to be really specific. The Due Process Clause does not say anything very specific, so that would not negate the discretionary function exception.
Certainly not here. There's not a plausible allegation of a
No, I know,
constitutional
but that's
violation.
a different
Yes.
argument. I was surprised when I read your brief. I understood your brief to be accepting the general proposition, without this refinement, that a constitutional violation negates the discretionary function exception. And I'm just really trying to get a handle on what the government's position is on that. So let's assume for a minute that a due process and equal protection violations were adequately alleged. In your view, would that effectively nullify the discretionary function exception?
I do not believe so, Your Honor.
Okay, I did not get that from your brief. That seems, but you think that's somewhere in your brief?
Your Honor, our position that we took in the district court and on appeal has consistently been that there's not a plausible constitutional
I
violation.
know, but
alleged
I'm
here.
asking you,
Yes, Your Honor.
yeah, the hypothetical
Yes,
question.
and-
What if there had been?
Yes, and I don't believe that hypothetical issue was reached in the brief because we were dealing with the complaint that is before us as to the factual allegations that are alleged. I believe we do cite Medina. We do cite that sentence there.
And Medina is very broad. It doesn't say
Yes.
anything about the constitutional violation has to be specific.
Right, Your Honor. Yes, there's just the
Because
sentence
so
from.
few of them are. Like, I'm just trying to figure out, in your view, then, what kind of a constitutional violation might nullify the exception? Because I guess if someone under 35 runs for president, is there anything else?
Your Honor, I guess I will answer your question with the main point being, I guess, that the court doesn't need to engage in this line drawing here because the government's position is the case falls well within discretionary function. There's not a plausible constitutional violation. But to answer your question, Your Honor, if we took the Fourth Amendment, for example, there's a clear prohibition against unreasonable searches and seizures. And just as a hypothetical example, if a law enforcement officer were to enter the home of someone without a warrant and without any exception to that warrant requirement, and in the course of doing so were to commit a state tort, and a lawsuit were brought under the Federal Tort Claims Act, that may closer to falling outside of this boundary of the discretionary function exception. There's a clear prohibition in the Fourth Amendment as to unreasonable searches and seizures, and so as long as there was sufficient allegations of constitutional violation of a state tort that is being alleged, because ultimately in a Federal Tort Claims Act lawsuit, there's state tort claims that are being alleged. And so, for example, if there was an assault claim or a false arrest, and if that claim fit within the law enforcement proviso of the Federal Tort Claims Act, that might fall outside of the discretionary function exception. But our position, as I said below, and in this court has consistently been that there's not a plausible constitutional violation alleged as to the Equal Protection Clause or as to due process. There's a passing reference to those provisions in the complaint, but it's cursory allegations that aren't sufficient. In any event, this court, in applying the Galbert test, in the two parts of that Galbert test, the district court correctly applied that and determined that this challenge conduct here that involves investigative and prosecutorial decisions, that this conduct fits squarely within the discretionary function exception. As to the first part of the test, where the challenge conduct involves a judgment or choice, the Fourth Circuit in Blanco Ayala said there is discretion in the FBI's investigative choices. And in Medina, the court recognized the decision to initiate a prosecution has long been regarded as a classic discretionary function. I believe Judge Benjamin asked the opposing counsel on their side as to that, as to prosecutors and how they have discretion in determining when to bring charges against an accused. As to the second part of the Galbert analysis, the challenge conduct here is based on policy considerations. Blanco Ayala, again, tells us that decisions on how to conduct an investigation, what to do with information that's obtained in that investigation, and ultimately whether to prosecute are all infused with public policy considerations. Officers have to exercise time and legal resources in determining how to weigh different evidence they're receiving during an investigation in determining whether to pursue charges. In Sutter, the Fourth Circuit explained that imposing liability for these kind of decisions would seriously handicap the FBI and other federal law enforcement agencies in carrying out their duties, and it would stymie the very purpose of the discretionary function exception, which is to permit or to recognize that there's separations of powers here and to prevent any second guessing of by the judicial branch of any policy decisions through this mechanism of lawsuits against the federal government.
Counsel, can I go back to the constitutional question?
Yes, ma'am.
And as you say, the district court said that these allegations were too thin and conclusory to sort of sufficiently plead the violations. But I guess I am wondering what else would be necessary, because the facts that were alleged here were so bad that the FBI knows that this young black man has a confirmed alibi for the murder. They know that local officials think it was actually a white person who committed the crime, but they just target this young black man and they charge him with a robbery for which he's already been penalized in the state system just to squeeze him on the murder. And they disclose all kinds of information, incorrect information about him into the community. And then eventually, of course, the white man is convicted. If that's not enough to adequately allege, I guess I could start with the due process violation. What else do you need?
Your Honor, as to this, is the complaint makes a passing reference to these provisions. This is in paragraph 68 of the complaint, that the selective enforcement is mentioned, and then in paragraph 248 of the due process is mentioned. I mean, certainly this court has explained as for selective enforcement, there's a demanding burden there to show discriminatory effect and that an officer was motivated by a discriminatory purpose.
I know, I just wonder whether, I totally agree, you need to show the motivation. And I did not see that expressly alleged, but I mean, on the facts as alleged, like what else could it be?
So there are facts. This is a very lengthy complaint, as I'm sure your honors are aware. There are lots of allegations, and at this stage, the court accepts the factual allegations, right? And there are factual allegations that white individuals, the individual who ultimately confessed the murder and his girlfriend, there are allegations as to them and as to investigative steps the government took in this investigation as to the kidnapping and murder. And just to name a few examples to compare to the alleged treatment of the African-American plaintiff here, Mr. Taylor. Mr. Taylor alleges that at the time of his arrest for the armed robbery that he was lied to, that told that he was under arrest for kidnapping and murder. There is an allegation in the complaint that the white individual, the girlfriend, was lied to by the government and told that there was evidence linking her via pings from cell phones, that there was evidence from her phone linked to the victim who was killed related to that investigation to the kidnapping and murder. And so there's this evidence as to law enforcement's techniques, these alleged techniques that were taken as to these individuals of different races. There's also an allegation that Mr. Taylor was arrested on a pretextual basis to get information about the kidnapping and murder, although the arrest was for the armed robbery. And there's an allegation as to the white individual, the girlfriend, that she was brought to the FBI on a pretextual basis, but ultimately asked questions about the kidnapping and murder. And so I think even within the complaint itself, there's these allegations that cut against any argument that there was selective enforcement of the law, which, as I said, there's a demanding burden upon a plaintiff to allege that that there is selective enforcement, to show discriminatory effect between individuals of different races, and that an officer was motivated by discriminatory purpose. And none of this was brief, certainly, as I said, because the government's position has always been that there's insufficient allegations as to constitutional violations. And as I believe Judge Harris pointed out as to the, in the prior opposing counsel's argument, that there isn't much sort of pushback, that we see in their briefs, certainly not before this court or in the district court. So this elaboration, I guess, that Your Honor, Judge Harris, you're looking into wasn't briefed, as I said, but our position has always been these are cursory, conclusory allegations as to a potential constitutional violation, and the district court correctly concluded that that these violations weren't plausibly alleged, and ultimately that the discretionary function exception bars these claims based on the government's investigative and prosecutorial decisions.
I do want to ask you about the allegations regarding the robbery, the McDonald's robbery, because you talked about selective prosecution, and I mean it is odd that I think he's convicted in 2011, and then the FBI comes back in 2016, following the kidnapping and murder of the victim in this case, and decides to charge him in 2016, which was, I guess, like 5 years later. And as to you brought up the selective prosecution.
Yes, Your Honor. I believe the robbery was in September of 2011, and the grand jury indicted Mr. Taylor in June of 2016. This was within a 5-year sort of statute of limitations for the federal prosecution. Our brief, I believe it's in footnote 3, that we cite the district court, a district court opinion from the court that presided over the federal prosecution, and explains how the government here went through layers and layers of approval to get a pettit policy waiver. The Department of Justice has a policy that generally prohibits successive prosecutions when there's already been a state prosecution to then have a later federal prosecution. But here, the government obtained a waiver of that and had to go through layers and layers of approval there.
How come? Was there something like especially egregious about this McDonald's robbery?
So my understanding, and this is from that district court opinion that we cite in our brief, is that the government, at a hearing before the district court in the federal prosecution, said that the substantial federal interest here was as to the leniency of the sentence that Mr. Taylor had received in the state case. My understanding is that he had a probationary sentence, whereas he had 2 co-defendants, one of which had shot the McDonald's manager in I believe it was a hand in the leg, and that person was given a sentence of 25 years imprisonment.
But that's because he shot the person.
Right. There's another co-defendant that had up to 6 years in term of imprisonment, and then the appellant here got a probationary sentence. And so my understanding is this was one of the considerations for the government as to the leniency of the sentence that Mr. Taylor had received in the state prosecution. That was one of the considerations, as there are with any kind of prosecutorial decisions, there's considerations as to nature of the offense and what is the government interest. And like I said, there were layers of approval that had to be obtained
But
here.
does it matter that he was indicted on it, but nothing else happened after that, on that charge?
Right.
I mean, it kind of would go to the allegations if you're talking about selective prosecution. I mean, he was never prosecuted for it.
So Mr. Taylor was indicted by a grand jury on 3-count indictment, and he pled guilty to one of the counts. And all these counts stemmed from the armed robbery. So his, I believe the first count was a conspiracy to commit Hobbs Act robbery, the second count was the armed robbery, and the third count was possession of a firearm and furtherance of a crime of violence, Section 924C offense. And he pled guilty to, I believe it was a conspiracy. He was sentenced, and at no point has he challenged the federal conviction or sentence, which gets us to the Heck versus Humphrey, another ground on which, the court here could affirm the district court's dismissal. I think Judge Harris brought this up as to, to the extent any of these claims are based on a challenge, constitutional challenge, that is, as to Mr. Taylor's federal conviction or sentence, that claim's barred by Heck versus Humphrey. Because Heck versus Humphrey requires a showing that the federal conviction or sentence was invalidated, and also that the plaintiff brought the claim while in custody or could have brought the claim while in custody. But here, Mr. Taylor did not bring this civil lawsuit while in custody, and there's no allegation that he was prevented from doing so while in custody. But certainly there's no invalidation at all of his federal conviction or sentence.
Can I ask you about the, since you raised the Heck part, about the district court sort of alternative holdings under Heck and the defamation exception? And I think we have to, well, let's assume for a minute we kind of take that as a given since they've never been challenged. In your view, do those two things together cover all of the claims in this case? Would those two rulings together, the Heck bar and the defamation exception, be sufficient to dismiss the entirety of this case? Or are there claims that are neither arise from defamation nor effectively challenge the robbery conviction?
And is just before answering your question, does that question assume the discretionary function exception
No,
issue also applies, or that doesn't? Okay.
Assume all we've
Got
got
it.
is Heck and defamation.
Got it, yes. Yes, Your Honor. And so I think that would cover the entirety of the complaint here.
Okay.
I know there's not an official defamation claim in the complaint. There's three other claims, but this court has said that the labeling of claims doesn't necessarily mean something isn't one for defamation, and here certainly the allegations are that the government made untrue statements about Mr. Taylor at the detention hearing, and that this brought harm to his reputation, which is essentially a defamation claim, if not by name. And so I think that this covers the realm of the allegations in the complaint.
So the one sort of question I had is, I agree that you don't have to call it defamation if it arises from something that is defamation. It falls under the exception, and I do agree that that would cover the heart of the claims about the FBI's statements. What about the claim that, okay, but in 2019, once everybody agrees the FBI no longer treated Mr. Taylor as a suspect, they never came forward and corrected the record? Would that be covered by the defamation exception in your view?
And I understand that claim goes to the duty, and maybe that's the negligence claim that you're referring to, and there is a negligence in
Yeah, and
gross-
it also
right.
shows up a little bit in intentional infliction, but it's the
Right.
heart of the negligence claim.
Right. And I think certainly our position as to that is that there's a failure to state a claim and to allege any duty under the 12b6 part of our motion to dismiss. And
But that,
yeah.
would that survive the defamation exception and the Heck bar?
I don't think that would, I think that claim falls more into the Heck realm, because the claim stems still from that federal prosecution where Mr. Taylor, during the defamation hearing, the government asked for detention, and in part because he had been identified as the suspect. And this allegation is to duty to correct the record. I think it still stems from the events underlying the federal prosecution, and Heck tells us that when there's a challenge as to the federal prosecution and a conviction or sentence, that isn't permitted when there's a constitutional violation that is alleged. And certainly this court can reach these other grounds, can affirm on any ground that is apparent in the record. I think Judge Harris asked opposing counsel as to waiver, or is there any concern about waiver here, about these grounds that aren't raised at all in his brief on appeal or before the district court? And our position is at this point, after there's been briefing and an opening brief and a reply brief that has failed to address several of the grounds for dismissal, that these arguments have been waived. They haven't been either brought, I see my time is up, but.
You can conclude.
Okay, yes, Your Honor. I was just going to say that the arguments either haven't been made or haven't been fully developed. Thank you for your time. The government would respectfully ask that the court affirm the district court's dismissal of the complaint. Thank you.
Thank you very much.
Opposing counsel says that not applying judicial or discretionary immunity here would stymie law enforcement. The only Only thing that would stymie would be law enforcement conduct that's intentionally bad conduct. It would deter that certainly if there was a holding that you can't frame somebody in order to frame somebody else. We would hope that that conduct would be deterred. Our law should deter that kind of conduct. Any type of normal sort of, the type of discretion described in Medina, we're not challenging, we're not saying that the people should be allowed to second guess ordinary charging discretion decisions. But again, this is a very unique case. And as Judge Harris said, we pled essentially everything we could think of. This is a very difficult case, obviously, to plead because, like I said, you kind of bump into different walls because the McDonald's robbery standing by itself could be justified. Although I will note that the FBI was never shy. The U.S. Attorney, they were never shy about why they really brought that. That wasn't really brought because of any leniency. Mr. Taylor was a kid when it happened. He got a youthful sentence. He served it. They made it very clear in that bond hearing. They brought him in there to squeeze him. And they said there were going to be more people coming forward to say that he and his dad had done this. And it's not just that's defamation. That is a choreographed use of the federal law enforcement machinery for a bad purpose by actors knowing that what they're doing has no merit, that it's untrue, that it's for a bad purpose. There's no way that our law can countenance this kind of behavior. As far as whether I've waived anything or anything like that, I mean, like I said, we've pled the best we can, but on a 12b6 standard, I believe there's some case law that says that if it doesn't just look to the counts, it looks to the facts. And so once again, I'll just conclude by saying, on these facts, and the 69 pages of that complaint, on those facts, does an American citizen have anything that he can legally complain about? Because
Mr. McKay, can I interrupt you for a second just so I understand
Yes, Judge.
where you think the precise violation actually occurred? So, and you can correct me if I'm wrong about the chronology, but at least in the initial stages of the FBI's investigation of this murder, they had an informant that had pegged your client as a potential person involved, right? And so, is that right?
Well, no, about midway through, that was about 2016.
Okay. When does the alibi come in?
Well, the alibi comes in 2009, almost immediately afterwards.
So the informant comes in afterwards.
Well, it's kind of, afterwards. It kind of is confusing because they claim they had heard different things at different times, and it's kind of hard to ferret out what that really is because the FBI, of course, hasn't shared all their materials with me. But it was about 2016 where they're going to charge Mr. Taylor. They go to his hometown right there by where he and his family live, and they basically put the word on him that the killers are here in this community. Then they arrest him and bring him into court and say that he and his father did this, that they sold the girl into prostitution, that they fed her to alligators. This is outrageous behavior by the federal government. And doing that, they knew that that wasn't true. They could not have possibly believed, under what we know and what we've alleged, that that was the truth. And they want to sort of say we get away with all of it because technically we could have charged the McDonald's robbery federally. It doesn't pass sort of, it's a little too cynical to even pass the common sense test. And I would just say, it's not to whether I've waived something or whatever. If I may not be the best lawyer in the world, but I've pled everything that I could think of to tell this story, this parade of horribles of things that occurred here. This court, I think it's for this court to look at the facts that we've pled and just answer that question simply. On these facts, does an American citizen have a recovery against the government.
All right, thank you, Mr. McKay.
Thank you.
All right, I want to thank both counsel for their arguments. We'll come down and greet you, move on to our third and final case. All right, be seated. Our third and final case this morning, 25-2177 Driggs versus the Central Intelligence Agency. Mr. Clark.
Good morning. John Clark, on behalf of the plaintiffs in this Freedom of Information Act lawsuit. There are a number of issues that the plaintiffs have raised. I'll start with what I believe is the most important one, and that is that issue regarding bad faith. Now, the issue there is whether or not bad faith in the underlying activities which generated the records at issue may be used to overcome the presumption of good faith ordinarily accorded to agency affidavits. Now, the plaintiffs cite two cases in support of their position, Jones v. FBI and Ruggiero versus FBI. In Jones, the issue was COINTELPRO, which the Jones court described as a sophisticated vigilante operation aimed squarely at preventing the exercise of First Amendment rights. Now, under the district court's view in this case, that would have been entirely irrelevant as a matter of law.
Counsel, can I
in
ask
the
you-
reporters committee.
Oh, Counsel, sorry, can I ask you, even if we were to assume that Jones was right, that case seems different because everybody had conceded sort of the underlying bad faith when it comes to COINTELPRO. Like, that was sort of openly and notoriously in bad faith. But where is the evidence of bad faith here?
The evidence, we have significant evidence of bad faith here. That's the second issue that we raised, is whether or not the plaintiffs had sufficiently demonstrated bad faith in the underlying activities that generated the records at issue. And I suggest, well, first of all, the district court said it's irrelevant.
I know, but I'm just trying to figure out whether the legal issue matters in this case, because it just looks to me like what you have is evidence of a disagreement, to be sure, between Senator Smith and then the CIA and Department of Defense, and maybe even, assume for now, as alleged, evidence that the NIE, and I can't remember what that stands for, that the NIE was wrong. But that's different from bad faith. I mean, there can be a mistake that is not bad faith. So where is the evidence of actual bad faith
Well,
here?
the evidence of actual bad faith, I would suggest, is in Senator Smith's 160-page review
Yeah.
of the NIE, which is the National
Thank you.
Intelligence Estimate. And the National Intelligence Estimate was 33 pages. Now, Senator Smith took excerpts from 40 excerpts of that 33-page National Intelligence Estimate, and I think just destroyed the credibility of that National Intelligence Estimate. And not only does Senator Smith make a very compelling, I think, argument that the National Intelligence Estimate did not properly, interpret the evidence. But the National Intelligence Estimate even left out evidence that Senator Smith gave to the author, and they just didn't mention it. I think in the plaintiff's opinion, it was clearly made in bad faith. I mean, this has been going on for, something like 40 years. And there have been significant efforts to get the government to reveal what it knows about the 600 men that were left behind at the close of the Vietnam War. So
In Jones and Ruggiero, it seems as if there's this very high standard to do what I guess you're trying to do here, to apply the collateral bad faith. So I guess what I'm asking is, what here meets that standard?
The question of what is the burden of proof is I don't know what the answer is. That the two cases that we cite don't really say. One of them says that it's a high burden of proof. Now I don't know. It would seem to me that a preponderance of the evidence would be the burden of proof. But maybe it's clear and convincing. There's really no direction on that. But I would suggest to the court that even if it is clear and convincing, the Senator Smith's 160-page review met that burden, I think, clearly. And also the district court said that it was irrelevant as a matter of law, and that they did so, but then he went on.
The district court did go, I was just about to say, sorry, the district court did go on to say, and anyway, I don't think you could meet that standard.
Right, that's exactly what the district court said.
And I guess we're sort of focused on that piece of it for
Yeah,
the
well,
moment.
the government argues that that finding by the district court should be reviewed on a clear error standard. And that is not accurate in my view. It should be de novo, because the court said it's not relevant as a matter of law, and that would be a review de novo.
Well, that we would review de novo, but I really am struggling with kind of, if we were to assume for a minute that the Sixth Circuit standard applies, collateral bad faith suffices, I'm just trying to figure out how we tell the difference between a heartfelt disagreement between Senator Smith and these agencies, even a lengthy disagreement with lots of pages. That's just a disagreement. You interpreted the data wrong. You didn't look at all of the right stuff. That is, I think if we were to say that by itself amounts to bad faith, we would be opening up an extremely large exception. There are always heartfelt disagreements about what the government is doing.
Well, I wouldn't characterize this as a heartfelt disagreement. I would characterize it as a cover-up. And I think
Well,
that...
I know, but I'm just wondering, I also don't think we can decide based on how a dispute is characterized by one of the litigants. Like, we would be looking for actual evidence of bad faith.
Yes, Your Honor, I think the evidence of actual evidence of bad faith is evident by the plethora of information that the NIE omitted that Senator Smith actually gave to them. So that's my
Okay.
view on that. The district court also said that the Fourth Circuit has not adopted the view that the Sixth Circuit has. That is correct. However, they have not rejected it either. In fact, no court in any jurisdiction whatsoever has rejected this.
So you don't think in our Young case that there's a rejection of this collateral bad faith? Young. Because that's the case that the district court cites, is Young, characterizes it as a kind of...
My recollection of that case was it had to do with in-camera inspection, but I don't, the court did not, in Jones, to my recollection, reject that, nor, and I think if they had, the government would have cited it for that purpose, but that's my understanding. And in this de novo review of the evidence of bad faith, I would respectfully suggest that the court review the record to see whether or not that the plaintiffs have proved bad faith. So And next, the plaintiffs also argue that the CAA did not meet its burden to show the applicability of the exemptions that it asserts. Now, the context of this information that is redacted, we know what it is that is redacted generally, and that is what the Russians reported regarding unrepatriated Vietnam War POWs. Now, the government argues the fact that this addresses items that occurred over 50 years ago is irrelevant. I would suggest to the court that that is not true. The CIA fails to provide any explanation of how the information provided by the Russians could possibly undermine national security. None whatsoever.
Well, but the rub there is that when you're dealing with information like this, there's always a difficulty and a challenge in being too specific, because if you're too specific, that eliminates the very purpose for which the exemption is being requested, right? You've got this affidavit from the custodian of records. She asserts, I will admit, fairly conclusorily, that the disclosure of this information would damage national security, disclose intelligence sources, methods of intelligence, that kind of stuff. And it stops there without going into further detail. But the reason why it stops there is because if you give more detail, you've essentially disclosed the very information that you want to keep secret.
That is a point well taken, but I have asked the government for just an explanation of how it possibly could fall into one of these exemptions, and I haven't got an answer. They responded that the plaintiffs are not entitled to such granularity of detail. But if you think about what it is we're talking about here, we're talking about what the Russians said about unrepatriated U.S. POWs from the Vietnam War. How is that going to interfere with, and again, over 50 years ago, how is that going to interfere with national security? I don't see how it could. I've asked for an explanation, and I haven't received one. The plaintiffs suggest that the reason that the government is withholding this information is because it would further embarrass them. And Executive Order 13526 says, and I'm quoting, prohibits classification to prevent embarrassment to a person, organization, or agency. And I believe that that is exactly what is happening here. Now, another issue that the plaintiffs raise is that they suggest that the district court erred in denying plaintiffs' motion for in-camera inspection. And the court in Allen versus CIA, a District of Columbia case, set forth 6 factors that the court should look at to see whether or not it would be appropriate for in-camera inspection. One is the conclusory nature of the agency's affidavits. We've covered that. The court commented on that. That's the way we look at it. Another factor is judicial economy. We're only asking that the court review the redacted portions of just 29 pages. I suggest that that would not be difficult for the court to do. Another factor is disputes concerning the contents. We believe that we have good cause to question the CIA's explanation for its withholdings. And then there was bad faith. We've talked about that. And then lastly, there's strong public interest in disclosure. Now, this information is part of a much larger advocacy that spans almost 50 years by family members, journalists, authors, organizations, congressional committees, at least 3 administrations, and an act of Congress, all seeking to prompt the government to reveal what it knows about this.
Counsel, I'm sorry, I am confused at how we think about those factors for when there needs to be in-camera review if we agree with the district court that the affidavit was, in fact, sufficient. If the affidavit is sufficient, do you still have to run through all of those factors to decide that you don't want to also do in-camera review? I thought we had said in Young that, look, if the affidavit is sufficient, obviously in-camera review is unnecessary, and you only apply those factors if you think the affidavit might not be sufficient.
I believe that the court suggests that, or at least the court in Allen suggests you look at all of the factors, take all of that into consideration, and then.
Even if the affidavit is sufficient.
Well, you know, as we've discussed, the affidavit is not going to.
Right, that was my question, whether these are two independent arguments you're making, or whether you are arguing, whether the premise for your argument about in-camera hearing being necessary is that first we agree that the affidavit is insufficient.
I don't think that we have to agree that the affidavit is insufficient in order to reach to go to those 6 factors. So I think that the
But
answer.
I guess just as a matter of common sense, if a district court finds the affidavit is sufficient, I am persuaded that the exemptions apply. You think you might still have to go ahead and do an in-camera review?
Yes, because, yeah, that would be my position, particularly since we are talking about the disputes concerning the contents, and again, the plaintiff's question, the CIA's explanation. Also, the plaintiffs argue that the CIA, about a provision of the CIA Act, which is an exception to the ordinary circumstance where the CIA does not have to search its operational records, period. You don't even have to search them. And it's a very short portion of the CIA Act, 3141 F3, and I'll read a part of it. When a complaint alleges that the requested records were improperly withheld because of improper placement in solely exempted operational files, the complainant shall support such allegation with a sworn submission based upon personal knowledge or otherwise admissible evidence. Now, we did that. We submitted a affidavit from Senator Smith based on personal knowledge, and we also submitted an affidavit by Kevin Shipp, who's a former CIA employee who held classification authority, and they both said that it was improper withholding. Now, we also cite at least one case, we know of at least one case, Hall versus CIA in the District of Columbia, which held that these affidavits were sufficient to trigger the CIA to have to search their operational records. And we cited in that case the affiant, one of them was Senator Bob Smith, just as in this case. So also.
Can I ask you a question about Hall? I thought Hall had to do with a different subsection of the statute, F4, not F3.
Well,
And F4 talks about allegations that requested records were improperly withheld because of an improper exemption as opposed to an improper placement. Is there a difference?
Well, that's a good question. I think that there is not a difference, and I would
Well,
say.
the statutes seem to make a distinction. They have 2 separate subsections, one for an improper exemption, meaning, yeah, and frankly, I'm trying to figure out what the difference is, but F4, F3, the 2 different exemptions. Hall talks about F4. You're talking about, you relied on F3, but go ahead.
Yeah, I was just going to suggest, to alert the court that most of the Freedom of Information Act requests that we made in the district court were for records of the POWs that were not unrepatriated at the close of the Korean War, and that's 75 years ago. And we would suggest that improper placement should be read to include improper retention after 75 years. I see my time has expired.
You've got some time left for rebuttal. Thank you, Mr.
Thank you.
Mr. Metzger.
Good morning, Your Honors, and may it please the Court. Assistant United States Attorney Matthew Metzger on behalf of the Central Intelligence Agency, CIA for short. At issue, this case boils down to 2 key issues. First, whether the district court properly upheld the CIA's exemptions under FOIA Exemption 1 and FOIA Exemption 3, and second, whether the district court properly concluded that the CIA was under no obligation to search its operational files. As there was no error, this court should affirm. I'd like to start first on the withholdings issue. As this court is aware, withholdings were made under exemptions 1 and 3, and this court can affirm on either basis. And I'd like to start this portion on exemption 3. There are two burdens that the government must meet. First, in identifying a withholding statute, and then identifying whether the information in the underlying records falls within that statute's coverage. My friend has not disputed that we've properly identified two withholding statutes here, the National Security Act and the CIA Act. Indeed, both the Supreme Court as well as the DC Circuit Court in Tobacco have acknowledged that both such statutes meet the parameters of B3. And then, as reflected in the Williams Declaration submitted in the joint appendix, we described how the underlying 23 pages of information fall within these statutes covered. And we would submit—
So your colleague on the other side says that that description just isn't sufficient enough to provide a sound basis for deciding whether or not the information should be exempted or not.
So, Your Honor, I would first direct this court's attention to Bowers, which reminded that the touchstone of the analysis on the government's justification, particularly in the national security space, is to provide generic disclosures. And that was the word this court used, generic, quoting this court's prior decision in Spanhouse, I'm sure I'm not pronouncing that correctly, which in turn cited Supreme Court precedent. So to say that we are required to provide granularity would run counter to this court's prior holding. And second, we did provide a lot of particularized information here. The declarant refers to the report itself, so it's not just engaging in the abstract with national security concepts. It's addressing the 23 pages that are in dispute with the parties and articulating what is underlying there. And I think, given the context of this information, particularly what my friend has admitted here, if we're talking about information that's coming from the Russians, given the context of looking for prisoners of war on foreign soil, it is easily conceivable to think that the United States government is drawing on foreign sources that we need to protect or at least instill confidences. And the reason we do that, I would ask this court to look at the remarks and the holding of the Supreme Court's decision in Sims, because we need to protect not just the underlying source, but the confidentiality surrounding those sources. Because if we lead any suggestion that there's the risk of leakage or spillage of information, our sources that we rely upon for our core intelligence gathering activities, the gravamen of the CIA's function, those sources disappear, and we're without recourse to have intelligence that we need to conduct the government's business.
Mr. Clark mentioned the passage of time. I think he said 50 years, and I don't have any sense of whether or not 50 years is a long time in the intelligence sphere, but maybe you can speak to that. His point is, it's been 50 years. Clearly, this information can't be all that relevant to national security.
I'd start first, Your Honor, in responding with the texts of the two statutes. There's no consideration for age, just the type of information that needs to be withheld from the public, and charging the director of the office, the director of national intelligence, and by delegation to the director of CIA, that this information is to be protected. In our papers, we cited several DC Circuit cases that say age is not a consideration to be accounted for. And ultimately, I can appreciate the court trying to wrestle with this question of age, but ultimately, understandably, there could be sources that, where if they are human sources, that, were young, could still be very much alive today. If these are generalized public sources, which we are allowed to rely upon, the Supreme Court in Sims touched on, we could be relying on them today as well. So the fact that so much time has elapsed doesn't really impact the FOIA analysis that we have before the court. I would make this observation, though, however, Your Honor. Time is relevant for the classification analysis.
Yeah, I was going to ask you about that, because the district court, I think, found that in December 2025, these documents would be declassified. Has there been a request, or, what's the status? Have the plaintiffs requested the?
Your Honor, I don't know if there's been a follow-up request in any respect. If there was, that would just be my friend dialoguing with the agency. In the administrative process, it hasn't come to any type of completion potentially, or reached the stage of my friend needing to initiate a new complaint because it's a new FOIA request. in federal court, as is his right if he feels that that's the vindication he needs to get the requested records. But we would submit that the time of the agency's disclosure here, and I think approximately 2024, and the district court's opinion was rendered in 2025, that is a frozen moment in time, because the FOIA doesn't impose, as a rough analog, the continuing updating obligation that's found in Federal Rule of Civil Procedure 26E. Otherwise, there would be no repose in the agency to give conclusion to any one FOIA request, and it's always why a requester can make follow-up requests. And I think that's particularly poignant in this space when the terms of the executive order set expirations on classification. It's 25 years subject to exemptions. Now, we have argued and do argue that the exemptions are applicable here, but the passage of time is something that the agency revisits when looking at these records, whether it's in response to requests from my friend or as required by Congress. There is a decennial review in which these questions are put upon the agency every decade. And so each decade, and the review is ongoing now for 2025 to cover itself to 2035, to examine classification matters, to examine just the touchstone of the language in paragraph G of section 3141. It escapes me, but all those considerations are at play for reaching if there could be a point where the joint report, once released, once withheld in full, now released in part, could ever then be released in full. And this is going to unfold potentially through time, but focusing on the snapshot that we have here, the agency looked to the underlying information and did determine that it was protected by these statutes and as well as classified under the terms of the identified executive order.
Can I ask a question about just FOIA generally, which is intended, I think, to be a sunshine act, right, that cuts across a great many agencies and entities, but it seems to be an odd pairing with the national security apparatus, which main purpose is to keep secrets, right? And so you talked about the first two exemptions that you're relying on, but then I assume you're going to get to these statutes that would, I just wanted to understand whether or not you think the statutes independently from the other exemptions cover the entire swath of information that the plaintiffs are seeking in this case, whether they independently would exclude all of the information that's being sought.
So the Honor's question is yes, the two statutes we identified, the National Security Act, the CIA Act, they provide the basis for exemption 3 to not disclose the information. And this is where within FOIA itself, there are two different competing interests. Congress said that generally, yes, to Your Honor's point, information is to be disclosed, government in the sunlight. But on the other hand, Congress made 9 exemptions of information that shall not be publicly disclosed. And I think as this court articulated in Power just recently in 2024, those are equally within the public interest not to be disclosed. So within FOIA itself, there's this inherent paradox too. And so yes, independently to affirm us, I would reiterate to the court that both the two statutes we identified, the National Security Act, the CIA Act, are a sufficient basis to uphold the redactions to the 23 pages of the report. And that's because, as noted in our papers, the redactions were made on both bases. So the court does not need to necessarily reach both of them. It just can rest on one or the other.
And does the issue of bad faith matter in that context? Or?
Your Honor, I would say no, because while this was not highlighted admittedly in the brief, I think the only consequence, if this court finds that we had in bad faith, obviously we dispute that point, is that adjusts the assessment of the submitted evidence. And ultimately then, the court can still find, based on what's been submitted, that we still have met our burden, it is our burden under the FOIA, to show that the redactions are in fact justified. And I think in this particular context, pointing again to Bowers, where this court said it is an imperative, and that's the word this court used, that deference be given to the national security declarants trying to uphold or justify the redactions, that is dialed back some. and in assessing the evidence that we be submitted. But of course, I would point to the court that this court's decision is young, as well as some DC Circuit authority have made clear that the bad faith, good faith analysis is linked to the processing and handling of the FOIA case. FOIA is not a reach into the rest of, underlying policymaking to ferret out different actions of the government. And I say that with a particular emphasis to this court's analysis in Simmons in rejecting a requester's discovery requests. There, the court made plain that the attempted requests to get information about the documents generation, goes too far for the reach of FOIA, because FOIA is ultimately about whether or not documents which are in fact responsive to a FOIA request go out the door pursuant to the FOIA's terms.
But just as a matter of common sense, can I ask you about that? Just imagine sort of a hypothetical, like COINTELPRO, where like it's kind of undisputed that the underlying conduct was in bad faith. I mean, why wouldn't that be relevant? If I appreciate that what we're looking at is the credibility of an affidavit that is subsequently filed in connection with the FOIA litigation, but why wouldn't it be relevant to whether you presume that that affidavit is in good faith or whether you worry that given the really the undisputed bad faith that underlies this whole thing, the affidavit might be part of an effort to sort of cover that up and avoid the embarrassment of that? I mean, they don't seem so entirely distinct to me.
Your Honor, I would say that they are distinct, and I think drawing from that is this ever need in FOIA litigation to bifurcate kind of the underlying, facts as they were revolving in real time versus the underlying processing of the FOIA request. And I think the Clinton decision from the DC Circuit kind of sheds light on this, because to suggest that the underlying facts, because I'm running out of words to dialogue here, become relevant, then surely a requester is entitled to discovery about them, because in some limited capacities, as this court recognized in Simmons, discovery can come about.
I mean, just again, it just seems like if you think there was bad faith in the underlying conduct, and then you get an affidavit saying, there is some information, but for the following reasons, we don't have to disclose it under FOIA. Like, couldn't that at least bear on whether you want to maybe do an in-camera hearing, just do like a little check of things? And I will tell you that, like, I feel this is a difficult time for you to be making this argument, because there really are questions these days being raised about the presumption of regularity, the presumption of good faith, that perhaps in an earlier time, courts didn't have as much reason to be concerned about. But right now, I have to say, I'm somewhat reluctant to kind of endorse a bright line rule that says we're not going to pay any attention to sort of what else is going on in this picture. We're going to kind of silo out this affidavit and look at the affidavit alone.
So I think, remember, in the larger context, it's about, first, there are really two core issues in a FOIA case. What was the nature of the search that was done to find records in response to the request, and then to justify redactions. Redactions are made on well-known bases, and there is, I don't think, that as in running through the list, there is a way to just shoehorn information to say, we're here to just package up embarrassment, or to safeguard embarrassment. As reflected in this record, they're pointing to tangible bases as to why the information was
And that might go to your earlier dialogue with the chief judge about whether, even if you did want to say maybe, even without the presumption of good faith, maybe this affidavit citing these two specific statutes withholding statutes might nevertheless be sufficient. But let me give you a hypothetical, and I hope it doesn't come across as overly inflammatory. But just as a matter of common sense, if someone sought records from DHS right now related to the ICE killings in Minneapolis, and DHS were to submit an affidavit saying, yes, we have responsive documents, but we're withholding them under certain exemptions, and you should just trust us. These are properly withheld under those exemptions. I have to say, I'd be sort of hard-pressed to kind of divorce the good faith of that affidavit from the rest of the picture?
So I respond to this court's hypothetical by thinking of the court's holding in Young, where it always made certain to categorically safeguard the district court's discretion, because
But this
if,
district court thought it didn't even have discretion to look at the whole picture.
the discretion in your hypothetical, Your Honor?
Yeah, I think this district court thought, as a matter of law, I can pay no attention to anything else that happened in Minneapolis. I just need to look at this affidavit. And whether, I think he did say, as a matter of law, collateral bad faith going to the underlying conduct is not relevant.
And I appreciate that the court asking this in terms of, sitting in the district court, but I think I'm reacting to, this appellate posture, which is if you're going to then reprimand or potentially reverse the district court's conduct, you would need to identify a rule to say this is an abuse of discretion. And if it's going to say it's forever linked to some type of predicate fact, if X, then Y. I think Young has foreclosed that, because it was just Young was reacting to, this is a small request, please review. This court said, this is dangerously close to a per se requirement of in-camera review, and we will not do that. So I think I'm reacting to this court's hypothetical to articulating a broader rule, as opposed to, and maybe there's a way it's announced that it could be a hyper-particularized one-off nuance that's 1 in a million cases to get away from what this court has already held in Young, but I'm not fully capturing it.
Can I follow up on that?
Please.
So it may be that, and I'm not suggesting that this will be the answer, but if we're satisfied that on this record there does not appear to be any evidence of bad faith, and so I want you to address that. There were 2 points that your colleague on the other side made. He latches on to the Senator Smith affidavit and suggests that there was a dispute between the CIA over the interpretation of that evidence, and the CIA rejected Senator Smith's explanations out of hand. So that's the first point. And the second point was that not only did the agency do that, but it ignored compelling evidence that cut against their position. With respect to the first issue, it seems to me that reasonable minds could differ as to how to interpret any kind of piece of evidence. That wouldn't seem to me to be bad faith. But a wholesale rejection of information that might lead to a different conclusion, that's a more difficult question. So maybe you can address why, on this record, those 2 things don't amount to bad faith.
So I start by saying, just by realigning the record, it's the first document ever at issue was the NIE. That's not challenged here. The second document is Senator Smith's critical assessment. I would note that that's been redacted, the same bases, B1, B3. My friends have not challenged that. So it's significant that the CIA is a good faith actor in redacting that document, the critiquing document. But then somehow when we issue joint report number 3, whose purpose was not identical to document 1, which is meant to serve as the final rebuttal instrument in this long dialogue, that becomes an act of good faith. And I think I am questioning Your Honor's premise of the question, because Senator Smith has not reviewed the redactions to the joint report or has made any critiques to the joint report, the document that's at issue here. So we have not even found evidence in buckets to draw out of to even launch at the CIA, because ultimately it was a different document that's at issue. It is not the same as the NIE. It's coming to different conclusions. Its purposes are different, and these are things that we've outlined in our papers. But I think because of those differences, that it is just a spirited disagreement. But ultimately, the brass tacks here, in my very remaining time, is whether or not information was withheld properly under exemptions 1 and 3. We withheld information in the critical assessment, the key instrument that my colleague is using as the government that the government is engaging in bad faith. That's not being challenged. And so we'd ask the court to affirm unless there's further questions.
All right, thank you very much. Mr. Clark?
Thank you, Your Honor. First off, no court has ever rejected the plaintiff's view of bad faith in the underlying activities. None. It hasn't.
I feel like the
if-
DC Circuit did. It said that would be too attenuated. We're really just looking at the affidavit and the conduct of the FOIA litigation, and going back beyond that would be too attenuated, no?
No, I don't think so. If this court were to adopt that view, that would mean other misconduct, like MK Ultra, extraordinary rendition, Iran-Contra, drug trafficking, search of Senate investigators' computers, human rights violations will all be out the door. Now, the Reporters Committee, in the Reporters Committee case, the Supreme Court said that the overall goal of the Freedom of Information Act is to open the inner workings of government to public scrutiny. And I suggest that the district court's view undermines that purpose. And as Senator or Congressman Billy Hendon wrote a book about these men that we left behind at the close of the Vietnam War, and he entitled his book "An Enormous Crime," and that's exactly what this is. The intelligence community has been lying to Congress, the American people, the families. It's an enormous crime, and I suggest to the court that that is the reason that they are withholding this information regarding what the Russians had said about the Vietnamese conduct in withholding POWs at the close of the Vietnam War. And again, I understand that there's an issue or a problem, can be a problem for the government to reveal too much in their affidavit, but I still cannot imagine how it is that that this information that is withheld it would undermine national security. Now, the government says, well, some of these people could even be alive, and that would be something that we should keep, if they were confidential sources, that's something we should keep, that they should withhold. Well, the government hasn't said that any of these people have not passed away. I would think that would be a condition preceding to making that argument. Plus, we've been at war with Russia for almost 4 years now. I just don't see how it is that the information that we're seeking, which is what the Russians had to say about the unrepatriated Americans at the close of the Vietnam War, implicates any national security issue. Thank you.
Thank you, Mr. Clark. All right, we'll come down and greet counsel, take a 5-minute recess, then come back and speak with our visitors from the North Carolina Bar Association.
This honorable court will take a brief recess.